All right, welcome. I am excited to continue this conversation. I have been speaking in the last few interviews with today's guest, Yi Tai Xiao. She's a licensed to practice law in California for 21 years. She also goes by the name of Linda. And Attorney Xiao obtained a bachelor's of law from the National Taiwan University, a JD from the University of Iowa Law School, and an LLM from Washington University, St. Louis. She had a few additional media exposures because of her history of outstanding advocacy in criminal defenses and a famous civil trial in San Francisco. The reason that this has caught my attention so much is because this is the first case in the U.S. To challenge the fact that a judiciary of the Supreme Court, we're talking the Supreme Court, the justices of the Supreme Court received a large sums of money or large gifts from an organization called the Americans Ends of Court. This is the first case to seek the disqualification of all 8 justices, and also the fact that the Supreme Court did not rule on the request for a recusal in this case. It's a very involved, very interesting case. Yi Tai Xiao, Linda, welcome back to the show.
Thank you. Good morning. Thank you, everyone.
It's good to have you back here. And yesterday we were talking about this. And again, for those who are just joining us for the first time, this is a case where Linda had, and Linda, I want you to correct me if I have the facts wrong, but Linda retained, Linda was in a custody fight, custody case. And so she had retained counsel, James McManis. And there was some conflict there between the court, who was also a client of James McManis. There were some irregularities where one day Linda showed up for a management conference, and the custody hearing just kind of blew up. She ended up losing custody of her child, which is, again, an irregular situation to have that happen during a case management hearing. She appealed. Then she found out that there were some conflicts of interest between the court in this Los Angeles County and James McManis, who represents the court as a client, and that was never disclosed to her. She also had some very, I guess, challenges, some irregularities when it comes to filing some things where they were kicked out, and they were, again, that's very irregular. I don't think I've ever heard of a clerk of the court not accepting a filing, and so there's just a lot of challenges, a lot of irregularities. The more Linda did her research, she found that there was just consistent irregularities. One of them was this connection between the justices of the court that she is asking for them to be recused, and this other organization called Ends of Court, where she says they have received, the Ends of Court has given these justices and their clerks special gifts, and that these gifts were never disclosed. Linda, did I leave anything out?
It's a wonderful summary, except that the trial court is not Los Angeles County, it's Santa Clara County.
Oh,
so,
Santa Clara.
Yeah, James McManus represents Santa Clara County Superior Court, but he did not disclose that when I retained him on August 23rd, or August 20th, 2010. He did not disclose the conflict of interest, and end up he was helping these judges to cover up their faults and sold my interest. So I was betrayed and sold, and then this kind of conflict of interest relationship was not uncovered until July 20th, 2015. He testified in his deposition that he represented Santa Clara County Superior Court as an institute. Also, he represents so many numerous judges, court clerks, courtroom clerks, bailiffs, court reporters, everyone, and every important role in a courtroom was everyone was bribed by him by way of free legal services.
Yeah,
and their personal, and their personal affairs. So he was so smart enough. He was so powerful to be able to manipulate the court, because he holds the confidences of these justices and important steps of the justices. So that is some minor correction regarding them. I mean, supplement. So okay. So I'm
going to talk about this. So I want to back up a little bit and talk about this. I want you to make the connection for me. So here we are. We have this conflict at the trial level, and of course you appeal that. It goes up before the U.S. Supreme Court. You find these additional irregularities, these conflicts between ends of court and the 8 justices. And so I want to talk a little bit more about this. We talked about it yesterday, but yes. As far as making that connection where where again the ends of court, or let me rephrase it, the justices, they can receive gifts if they disclose them, and they have to be under a certain dollar amount. And so we talked about that. The thing that I want to talk about a little bit more is the clerk's office irregularities with the amicus brief. And so I want to talk about that. And so let's start with that. Let's start with the what happened with the clerk's office and you trying to file your amicus. And this third party with their amicus brief. Let's start with that.
Yes, thank you very much. But would you please bear with me? Just make a small clarification. The 8 justices, they sponsored their clerks to receive a large sum of about $266,000. Is substantial. Annually, $7,000 for each clerk. So let me clarify that. I do not know how much money, how much awards the judges receive, the justices receive, but there are records published on the website, American Inns of Court, under awards. And if you go to the Temple Bar Scholarship, you will find the recipients. They stated that the justice sponsored. So this is a minor correction. And regarding the...
Okay, so let me ask you this.
Yes.
Since they are disclosing it on their website,
right?
Isn't that enough?
No.
Is that disclosure enough, or what else needs to be done?
They did not disclose. It's American Inns of Court. They want to elevate their own status. They publish the recipients and awards.
Got you. All right. So it's not a legal disclosure by the justices. It's this Inns of Court that are publishing it. So it's not the same thing.
Right. Also, they did not say $7,000. $7,000 is my estimate based upon 4 weeks free travel, free ticket, the free accommodation, and a tour, the free tour, 4 weeks in English, in London, in English area, plus a modest stipend. They posted modest stipend. We don't know how much is modest stipend. But according to the Guide to Judiciary, Section 620.35, both the justices and its clerks can not accept gifts annually more than $100 and cannot accept more for each event, cannot accept more than $50. So that is a clear violation. And the Section 620.50 of the Guide to Judiciary policies require disclosure. So none was disclosed, and the dollar amount is substantially more than 100 times for each court, more than 100 times, for each court. That it's just amazing that they failed to disclose. So $7,000 and $26,000 is my conservative estimate based upon the guided tour. The guided tour.
And again, from my point of view is, again, they have to disclose it. That's bottom line. That is the law, is that they have to disclose it. So whether they got $1 or $1,000, they have to disclose it. And as you pointed out, they're limited to how much they can receive. And so I guess one of my questions is, how does this tie into your case? Because the ends of court, maybe you can tie all this in for me, because the ends of court doesn't necessarily care about, like they wouldn't care about my case. They probably don't care about your case. So how does the ends of court, what's the word I'm looking at, influence the situation that has affected you so much?
Yes, I'm a person with standing. That means I am in prejudice. Why is that? It's because the subject questions in my 3 petitions for writ of certiorari filed with the Supreme Court since July 2017 and lasting until now. The current ones with the case number 17-613, all of them are focused upon the issue of lack of impartiality of the court, lack of impartial court. And lack of impartial court, for that issue, I asked the Supreme Court to issue certiorari regarding the function of American Inns of Court. That is, whether the judges and attorneys who have regular social relationship, they are members of the American Inns of Court, are required to disclose their relationship as a matter of law. And so that caused the conflict interest of these justices, because they have been mingling with the attorneys, have violated the Canon 3A4 of the Code of Judicial Code of Conduct for United States judges. That is to assure each judges have to assure none of the judges and their staffs have ex parte communications with lawyers. So he violated that code, ethical code for judges, federal judges, and also he violated the California Rules of Professional Conduct, Rule 5-300, which disallow any judges and important staffs to receive ex parte communication as well as gifts directly or indirectly from the attorneys appearing in front of them. So right now, the James McManis, he is a U.S. Supreme Court's admittee. He has many cases in front of the U.S. Supreme Court. So he is certainly involved. But now he is the respondent in 2 cases I filed. One is 17-82, another is 17-256. He is the respondent. And also, he is a interested third party to this current remaining case, 17-613, that is based upon my family court case. He is interested party because he represented me in a family court proceeding from August 20, 2010 until March 16, 2011. And he was sued for breach of his fiduciary duty against me by selling my interests behind my back to help these judges to cover. So he did not proceed anything. He did not take anything, try to help my child custody back. And it was purposely. I got the evidence from their telephone conversations. Michael Reedy, the partner who worked for this case directly, Michael Reedy's telephone notes with David Sussman, my ex-husband's attorney, stating, or David Sussman said, "Thank you for keeping it quiet." They have a chamber conference, and there's a conspiracy between David Sussman, Judge Edward Davila, and James and Michael Reedy not to file any motion to set aside the initial parental retrieval order of August 4, 2010. They all knew its violation of due process. They all knew my daughter, 5 years old, was irregularly abducted at a case management conference. They knew the case should be set aside. They talk about and talk into my attorney to betray me and to not to file any motion to set aside, which caused a status quo. And they used the status quo. That is, I lost the custody for a long time because they represented me for 7 months. And after I eventually was able to have my motion, I brought a motion to set aside by myself based upon the fraud and violation of the constitutional due process. It was eventually granted, but they argued that the court with another excuse that, oh, there's already a status quo, so I cannot return the child to you immediately. So that was the whole situation why I sued them. And they, I didn't know they have such a strong relationship with the judges and the court.
Right.
And they, in order to assert the only defense they have against me is to assert up to today, I still lost child custody. So even though they failed to do anything for me, even though they breached their fiduciary duty against me, I cannot assert damages because I still haven't got my child custody back. So, right. but now the new evidence show up. If you take a look at my the website at the shallchronology.blogspot.com, you can look into the expert's opinion. That is, there's a declaration filed by Mira Fox, attorney Mira Fox. You can look into the paragraph 4 of Mira Fox. She reviewed all evidence and she testified about her opinion as an expert. She said that this is the only defense. McManis Faulconer's law firm, including James McManis, Michael Reedy, and their law firm, can have as a defense to my suing them for malpractice and breach of fiduciary duty. And so they use that. They use a relationship, and the relationship was exposed in December 2015 when the jury trial of Shaw versus McManis Faulconer, James McManis, and Michael Reedy. This case, with a case number 112CV27571, that case was brought to jury trial, and they filed about 13 motions in limine to exclude, try to use their comrade, Judge Patricia Lucas' order in 2013, try to use that to assert collateral estoppel. That means, oh, there was a decision, you should continue be taken away custody, so we should not file. So
let's back up a little bit because we're using some words that a lot of people may not understand. And so these motions in limine, what is that?
That is very commonly brought at the beginning of the jury trial by a party to ask the court to exclude evidence or exclude issues to be discussed in front of the jury. So they try to exclude any discussion about how I lost the custody. They try to exclude evidence about the irregularities for a good mother to lose a child without due process, without any motion, notice, evidentiary hearing for such a long time. They try to suppress the evidence, and so that's called it's called motion in limine.
Okay, and then the other term that you used was something estoppel. I missed the first part. What was that regarding the estoppel or?
Collateral estoppel.
Collateral estoppel, meaning what? That this decision's already been established, so we don't want to litigate it anymore? Talk about that.
You are quite smart. That is exactly the meaning. That is exactly, they want to adopt the very irregular decision of Judge Patricia Lucas She is now the presiding judge of Santa Clara County Superior Court. And there has been recently, I think, in recent months, there were many demonstrations in front of Santa Clara County Superior Court to protest by the Taxpayers Association, object that the Santa Clara County Superior Court colluded by wantonly spending so much money to build up a gorgeous new construction, which is not necessary. So she was being accused of being involved with this financial scam right now. And I actually believe she does, because she was the president of the William A. American Indian Court, and she has more than 10 years social relationship very closely. She's like a bedfellow, was criticized by Mira Fox as a bedfellow to James McManis and Michael Reedy, but she did not disclose her relationship. Her decision in 2013, which is the underlying case for appeal right now for the petition number 17-613. This case, this decision that I have been appealed from, this one was written by, was signed off by her with about 5 pages of a statement of facts not shown in the trial at all. So you cannot find the transcripts in any of the 5 facts, 5 pages facts discussed by her. The decision, based upon what discovered later on, for her undisclosed relationship with Michael Reedy and James McManis, it appeared like that her decision was likely written by James McManis law firm.
Gotcha.
That 2013. So they try to suppress the appeal. There's no case like this that an appeal has been pending with the Court of Appeal of California's 6th Appellate District for about 4 years that I cannot file an opening brief. Why? Because she right now is a presiding judge. She was assistant presiding judge. During all time relevant, she was in charge of the court, and she directed the appellate unit not to prepare the records on appeal. And now I was not able to move on because no records appeal from the trial court. So it has been delayed. They stalled, S-T-A-L-L, they stalled my appeal for 4 years. I was unable to move on. So I filed with the court, the appellate court, asking to move away the venues, change venues of the Santa Clara County Superior Court, because I cannot have a fair hearing. I also changed the venue from 6th Appellate Court Appeal because the presiding judge, Kamali Rushing, appeared to be the client of James McManis. James McManis testified on July 20, 2015, that one of the justices at the Santa Clara County, at the 6th Appellate Court Appeal is one of his main judicial clients. So I believe that's him. So he also denied my motion to change the designation of records to allow myself to prepare the records on appeal. So he denied. So I had no way to change. I had no way to file records on appeal, and the only source is the trial court. And the trial court was controlled by Patricia Lucas, their bedfellow. They would not allow any appeal to move on. So this is the entire essence of this case going on, which will have a hearing of a conference in front of the 9 justices on February 23rd, 2018.
So next week.
Yes, but now the issue even more is the Supreme Court's conferences has been closed. No one knows what happened in the closed meeting. But all I know, one thing very clear is they purposely did not to rule on January 8, 2018 regarding my 2 requests for recusal. And so that is the reason why I want to impeach them. And you may be interested why I think the justice is willfully not to rule. Because
right. So I want to do this real quick because I do want to get into that. I want to point this out real quick because you know, this might be of interest to some of our viewers, and that is if you go to shallchronology.blogspot.com, you can see the evidence that Linda has collected, and so everything that she's talking about, she has deposited there for the public to review. And so if you want, you can go to shallchronology.blogspot.com and you can check it out. All right, so let's talk about this next step here. This, you know, how did you say it? The recusal of the justices. Oh, the impeachment of the justices, right? So let's talk about this because we're running out of time. So how do you go about impeaching these guys? And you know, if you impeach these justices, is that going to serve your case? Talk about this.
Yes, I need to have a fair hearing. Right now there's still one justice remaining. That is Justice Gorsuch. So if they think Justice Gorsuch alone cannot decide, which should not be there, because Justice Gorsuch is a very competent justice. So he's there to rule. If one think should have more than two, should have three, then the Supreme Court can arrange two justices who have no relationship at all with American Indians Court to decide as a temporary one. So this can be resolved, even though they are highest court. It can be resolved in that way, but they didn't do it. They have in the closed conferences. That means they conspire together. We will not issue a ruling regarding the request for recusal. And that is so significant, so improper, in violation of the Constitution, in violation of Canon 3, I think, of the Code of Conduct for United States Justices, that they have to read, they have to rule, they have to decide for the cases that is assigned to them. So
right.
So and also is discriminative. It's a violation of First and the 14th Amendment of the Constitution, because they cannot sort out my cases not to rule when they usually rules on all of the requests for recusal, which is standard practice to decide on the request for recusal for each one of them in the past. Why not only me? And not only that, I think you were asking me and I haven't responded. That was regarding the clerk's office irregularities.
Yes. So real quick though, I want to ask you this before we go to the clerk's the clerk's irregularities. So is it pretty common for justices to recuse themselves because they might have a relationship with a company, or they may have a relationship with somebody that's in front of them? So is it pretty common for them to recuse themselves?
Yes, it's very common, and so there's this U.S. Code, United States Code, Volume 28 U.S.C. Section 455. It applies from the lowest court to Supreme Court justices. Every judge is covered by this code, and it requires the judges to automatically, spontaneously, or you can call it sui sponte, to recuse themselves if they are aware of that. And also Rule 60 of Federal Rules of Civil Procedure, that authorizes the litigant to set aside the order when the judges did not, the judges, in a reasonable person's view, when they review the petitions, review the paperwork, they should have known their conflict of interest, but they fail to recuse. It is so-called fraud, F-R-A-U-D. And they consider this kind of situation to be fraud of judges and justices. But even though the judges or justices may not consciously know themselves, they may argue that we don't know.
Right.
But the test is a reasonable person test. If any reasonable third person who read the papers would know the justices, they should recuse themselves. They have conflict of interest. And the justices or judges fail to recuse, it will invite a motion to set aside, motion to vacate the order or judgment based upon Rule 60 of Federal Rule of Civil Procedure.
Gotcha. All right. So let's talk about the clerk's office irregularities, because this is, again, this is something that is very unique. I don't think, I've ever heard of this. So tell us what's happening with the clerk's office.
From September 2017, so the number one issue is they refuse to file the Amicus Curiae motion of mothers of lost children. For the first case, I sue against the McManis Faulkner. That is an appeal from the state case, and that's a case number 17-82. At that time, suddenly there was a supervising clerk show up with a clerk who never handled an Amicus Curiae. His name is Donald Baker. He was brought up by this supervisor to intervene into another supervisor's authority to file. So he decided not to file. At the same time, when the same motion was submitted for filing for another case, 17-256, that one was filed. But for this one, they purposely not to file. And when I make a question on October 23rd, 2017, my call was transferred to the supervisor who had the authority, and that is Jeff Atkins. So they joined together. Jeff Atkins allowed Jordan Rico to step in to disallow the filing. And who authorized this kind of conduct? It's so irregular. Who did this?
Right. So just so everybody knows, an amicus brief is by a non-interested third party. In other words, this person does not have a standing in the case. They're not a friend of yours. They don't represent you. They don't represent either side, but they have an interest in the justice of this case. So they will file this amicus brief stating their opinions, their findings, and why the judge should, decide this way or that way. They are there, again, as a non-interested third party, but they do want to influence the judge or the decision of the judge in one way or the other. And I've never heard of a court or a clerk not accepting an amicus brief, because, first of all, the clerk doesn't have that jurisdiction, doesn't have that power. They have to accept all filings. All of these filings become part of the court record. So this is outrageous conduct, isn't it?
Yes. And then there's another, again, so after 1782, they refused to file. They did not even return the motions to me. So the motions will just disappear. Hopefully, they still kept in the U.S. court, Supreme Court. But they supposedly, if they refuse to file, they should return to the attorney, Chris Katzenbach. They didn't do it. And now the same thing we played in the Thanksgiving time of last year. On November 17th, I filed another one for this case, 17-613, which is to be heard on February 23rd. So for this case, I filed, and they held up a filing on November 17th. I filed, but they held up until December 9th. After I made phone calls, I made many complaints to the supervisors, to the courts. I write emails, I complaints. Eventually, they filed it on December 9th. And then more interesting is, after I filed a request for recusal, they defiled a motion to remove it from the website on December 18th. They defiled it. When I found out they defiled, I made a lot of complaints. I told them it's a violation, it's a criminal action. The clerk altered the docket from accept the filing to be not accepted filing. They cannot do it. The clerk has a duty to maintain the dockets, but they alter.
The integrity of the docket is that's what the clerk's supposed to do. So you're saying that they went ahead and accepted your filing, and of course they delayed it for a couple of weeks, and then a couple of weeks after they accepted the filing, they defiled it. I guess they kicked it out.
Yes, 9 days, 9 or 10 days after they.
9 or 10 days after they accepted the filing, they defiled it, for lack of better terms. Did they return it back to you with some kind of explanation?
No, they just defile it, and they accuse the attorney, not for me, but they contacted Chris Kasabah. They accuse Chris Kasabah, you may not have e-filed correctly, but they posted. It was after they posted for almost 10 days, and they defile it, and then after I threatened, they ask Chris Kasabah to refile. So right now, if they refile, they did not docket a refile either. But this time, after refile, they correctly put on the docket that it was filing date. It was November 17. If you click on the website, the court, under the case number 17-613, and click the file open, you can see the file name itself shows the filing date to be 2017-2017. 12/19, December 19. So it's right. December 19th refiling. But interesting enough, the alteration of the docket entry is still there. You can see on the website of 17-613. At the bottom, you can see the irregular alteration of a docket. The trace, the evidence still there.
That's fine.
And now when I filed a renewed request for recusal on February the 2nd, together with the petition for rehearing in case numbers 17-613. Even though it's on the same day, they purposely docket the date for renewal request for recusal to be February the 6th. They purposely did that, and
okay. So let me ask you this. I got to ask you this, Linda, because there's a saying in the American justice system that what do you call it? A person who represents themselves. What's the saying? A person who represents themselves in court. It has a fool for a client. Something along that line. So here you are. You're representing yourself. Why not get another attorney to come in and help you and help you with this very difficult case? Why do it all yourself?
I cannot find anyone who dare to, because now I'm combat American Indians of Court. No.
Oh, gotcha.
No attorney would do it. And let me say that two very important things. Why this is purposely, and why the justice should be involved, and why these irregularities should involve the interference of American Indians of Court as well as James McManis. Why that I believe, in a public view, that this kind of irregularities happened in the clerk's office is illegal, is criminal, and why this will involve the third persons is based upon number one, that it's irregular for Jordan Recusal, a supervisor who never handled this proceeding, to show up and to block filing. Block filing twice. And number two is for this case 17-613. It was docketed on October 24, 2017. Within 24 hours after it was docketed, or I would just say it's about 17 hours after it was docketed. In the early morning of October 25th, 2017, Jeff Arkins walked to the docketing clerk, asking to alter the docket, to change the decision date from April 28, 2017 to June 8, 2017. And he also told the deputy clerk that the case name should be the respondent's name should remove James McManis and Michael Reedy. Only leave McManis Faulkner. How will he know that much? How will he know this? And how do I know? Because I was watching for the docketing. I called the clerk in the morning of October 25th, and he complained to me like a spontaneous complaint that he just
what do they call it? A spontaneous utterance, right? He just started.
Right. And so he spontaneously uttered to me that what he said, you talk to Jeff Atkins. You talk to him. I cannot argue with him. He will complain to me that Jeff Atkins even asked him to return the filing of my petition. Reader Curiae. So this shows who should be involved: James McManis and Michael Reedy, because they were asking the Jeff Atkins, apparently asking that their names should not be docketed anywhere in a court file. Should only put their law firm's name. That's McManis.
Hey, listen, Linda, we're out of time. I would like to have you come back on Monday. And let's see if we can wrap this up. This is such a very interesting case. This is one of these cases that a lot of people refer to as a David and Goliath case, right? In this case, Linda would be David, and she is going after, she is combating the system. And when you start looking at this, you have layers and layers and layers. And again, she's documented everything at chronology.blogspot.com. You can see it there. You can see everything she's talking about. And this is just one of these cases that people will scratch their heads, but the evidence supports everything that Linda's talking about. So if you want to find out, you can go to chronology.blogspot.com. You can see all the evidence there, all the accumulation. And then what's really nice is that she's got links to everything, so you can follow along. It's not like she's making this stuff up. This Inns of Court, she's done a lot of work with them, or a lot of research on them, and she can show you what she's talking about. So this is one of these cases that has lots of layers. Maybe hopefully on February 23rd, you'll have some relief in this case, and things will start moving forward. But Linda, I want to bring you back Monday and talk some more. Would that be okay?
Yes. Yeah, sure.
That'd be great. Thank you very much. You know what? I appreciate your time, and I want to wish you the best of luck. And then we'll talk again on Monday.
Thank you.
All righty.
Happy New Year. Happy Chinese.